Hello, I'm Niall Farrell. We've been involved in many probate actions and court disputes over the years. These have related to cases involving the interpretation of wills, or challenges to whether a will was valid or not, or more commonly what are called Section 117 applications. In the normal run, nobody has an obligation to leave anything to their children in their will, but Section 117 of the Succession Act of 1965 provides that if a child feels that they haven't been properly provided for in the will of their parent, then they are entitled to make a claim after their death. What the court will do is examine the circumstances of each party, that is the parent and the child, to see whether proper provision has been made, and it'll look at the circumstances of the relationship between the parent and child and the history of that relationship over time. Disputes can arise regarding the interpretation of a will, and indeed one of the principal cases in this area that sets out the law was a case in which we were involved many years ago. And what it provides is that if there's some confusion in the will as to what is meant by a particular provision, well then the court can take evidence from people who knew the person making the will as to what their real intention was. Another kind of dispute that can arise will be in relation to whether there was undue influence on the person making the will. Sometimes it will be alleged that the person making the will wasn't doing so of their own accord because there was such pressure on them, perhaps from a family member who hoped to benefit under the will. In general, we've lots of experience in this area and we have been doing it for 35 years. So if you have a question or a query in relation to this type of law, contact me. You'll find my details on our website.